So thanks for coming, and I'm here to introduce Patricia Collis, who is a senior associate at Bird & Bird and also a chartered trademark attorney. And she is actually a graduate of Cambridge. She did her undergraduate and her LLM here. And tonight she's going to talk about the role of a trademark attorney, so you become kind of acquainted with what trademark attorneys do, and then apply it in a particular issue that is the issue of the moment, and talk about how a trademark attorney might be affected by Brexit. So thank you, Patricia.
Thank you, Jennifer. So, thanks everyone for coming. Just a brief outline of what I'm just going to run through. So, a little bit about me, why trademarks, why I love trademarks, etc. Then, as Jennifer said, a little bit about trademark attorneys. Some of you probably don't know what a trademark attorney is or does, so hopefully by the end of this you will. And then the fun word of the moment, Brexit, which, my opinion, part of the reason that the Brexit side won is because Brexit had a better brand than the don't have Brexit side. Personally, I think it's an interesting branding issue, but anyway. And then a little bit about what the future is likely to hold. Now you'll see there's lots of question marks on here. There are lots of question marks throughout all of this because we don't really know, and every time I give a talk relating to Brexit, I have to revise it about 2 days before because something else changes. So we'll see what we can get to. So me, I studied law at Cambridge, so I was at CATS, and then I stayed on at CATS and did an LLM, and in both my undergrad and my LLM I did IP papers, so I did normal intellectual property paper in undergrad, and then I did the international intellectual property paper when I was doing my LLM. And slightly unusually, at least amongst the group of lawyers at CATS at the time, I went into law not necessarily wanting to become a solicitor or practice law, or not really being sure what I wanted to do. I was just interested in law as a subject to study. But then I obviously got to a point where I had to, make some life decisions. And in my law degree, the thing that I really enjoyed the most was the problem questions. I knew I much preferred problem questions to essays. That was my preference. I liked when we had something and you had to give practical advice to someone. And I really, really enjoyed IP, but going even further than that, I actually really enjoyed the trademark stuff that we did. And Jennifer's to blame for that because she lectured me on trademarks. I just really enjoyed that. And then actually through the career service here, I found out about trademark attorneys. So I'll talk to you a little bit about that. And when I found out about that role and what it was, it just really fitted. It's basically real life problem solving, doing problem questions all day, every day for clients and then paying you money for it. And in between that, I actually worked as a research assistant in the law fac for a little bit. So when I was doing my LLM, I was doing some research assistant work as well. So again, all in IP. So, trademark attorneys. I'm sure a lot of you know the distinction between solicitors and barristers. Then there's this other profession that's trademark attorneys. There's also the related patent attorneys that you may have heard of. People tend to be a little bit more familiar with the patent attorney profession than the trademark attorney profession. But effectively, trademark attorneys are lawyers who specialise in trademark law. So you start from the beginning doing trademark law. All of your training is on the job, so you don't have a training contract in the same way that a solicitor would. You do the training on the job and you have exams. Now the qualification system has changed a little bit over the past few years, and it's now run through Queen Mary University and Nottingham, and there are courses that you do whilst you're training or whilst you're working. So the firms don't love it because the people are off on these courses for sort of long weekends or weeks at a time, but the benefit is that you're learning as you're doing. So instead of it being a purely theoretical learning about trademarks and what you need to do to apply for a trademark, you're doing that every day. So when you come to the exams, hopefully there are things that you think, okay, I've done that in real life, I know what the answer is, hopefully. So that's generally how it works. Now, the whole idea of having trademark attorneys as a separate profession it is still a distinct profession, and there's still a different way to qualify from being a solicitor. But obviously there's a lot of reform happening to the solicitor qualification route. Recently the trademark attorney qualification route has changed. Traditionally, trademark attorneys worked in patent and trademark attorney firms, and solicitors worked in law firms. That's all sort of merging now. So a lot of the patent and trademark attorney firms have started doing litigation. So they've taken on solicitors, litigators to offer that to their clients. At the same time, a lot of the law firms who traditionally were dealing with the litigation have taken on the trademark attorneys so that they can offer to their clients the whole service all the way through. So I personally started off at a firm called Boatway Tennant, who are one of the top patent and trademark attorney firms in the country. But now I'm at Bird & Bird, who are obviously a law firm. So it's changing, and over the next probably 10 years, it's going to keep sort of merging together is what everyone thinks. Now, the impact of Brexit on that is another issue, because a lot of the patent and trademark attorney firms are UK-only firms. A lot of them will be London. There are quite a few about in Cambridge, Oxford, Reading. That's where most of them tend to be. There are a few scattered throughout the country elsewhere, but the biggest concentration is London, Oxford, Cambridge, general area. And obviously a lot of that is coming from people wanting to be near Oxford and Cambridge universities because of the innovation for the patent side of things, and then trademarks kind of sit together with the patents in the attorney firms. So it's all changing. So just to get into a little bit more about what a trademark attorney actually does. And this goes back to why some of the law firms now want to offer this service. Trademark attorneys basically get involved with trademarks from the very, very beginning. So, or at least as early as clients will let us get involved. So we get involved before a new brand is launched. So if someone is looking to launch a new brand or a new product name or a new sub-brand or something like that, we typically will be advising them firstly on whether they can do that, on whether, the way is clear, or does someone else already own that. Now, there are obviously lots and lots of trademark registrations on the register. A lot of, especially small companies, don't necessarily think of this. They do a little bit of Google searching and find that no one else is seemingly using the name they want for what they do. What they don't realise is that actually people could have rights that are on the register, and also that it's not just someone having the same mark already registered. It might be that they have something similar that's registered that could cause a block. So we do a lot of dealing with clients and doing these clearance searches, is what we call them, and then looking at that and trying to find a way through for clients, because a lot of the time you find when you actually look at the trademark register, lots of companies register trademarks that aren't maybe what they need. So the UK system and the EU system, it basically lets you register things. Now, in the UK in particular, you're supposed to have an intention to use the mark that you're applying for, but you can get through the registration process without having to prove anything on that. And the only way for someone else to get you off the register is to show you acted in bad faith when you filed that. And that's quite a high hurdle for people to show. So realistically, you can say, well, it was not inconceivable that, I may one day offer this type of product, so that's why I applied for it. So we deal with a lot of these clearance searches, and we actually deal with it across the world. So it gets interesting explaining this to clients, because actually if you look at other jurisdictions like the US, it's much more difficult to get a trademark on the register in the first place, because you actually have to be using and show that you're using, and you have to only cover very, very specific terms. Over here, you can get a lot of broad coverage relatively easily, but then that's sitting there blocking other people. So quite often, those with the funds to do so will effectively block up the register for others. So that's one of the interesting things that we get involved with. And also we're looking at this from, yes, a legal point of view, will you be infringing? But also from a commercial point of view, will someone else actually try and stop you? Are you likely to have someone trying to stop you take your product off the shelf if you do launch? Or is this a technical overlap and maybe you're willing to take the risk that they might do something about it? So it's interesting. So once we've done all of that, looked at what's out there, what does the register look like, what does the landscape look like, then we think about the way to actually get protection for clients. So I've actually put on both trademarks and designs here, and I'll touch a bit more on design issues later, because this is increasingly something that people are doing, is registering design rights as well as trademark rights. And actually Brexit has a bigger impact on the designs side of things than it does, or a more complicated impact on the design side of things than it does on the trademark side of things. So a big part of my job is actually getting people from an idea to having a trademark registration certificate and being able to, have that on their wall, or be able to say to other people, no, you can't use that, you can't register it, here are my rights. And it's the same on the design side of things. Now, designs are actually pretty easy to register. You put in your application, and there is no substantive examination to check that it is actually novel, etc. So you can get a registration, whereas for trademarks, the strategy is a bit more detailed, in that we have to look at, well, if you filed an application for this, are you likely to get a non-distinctiveness objection or a descriptiveness objection or something like that? And then if those things happen, we deal with trying to overcome them. So a lot of my work is dealing with the examiners at the UK Intellectual Property Office or the EU Intellectual Property Office, and explaining to them politely why the thing that they think shouldn't be a trademark or shouldn't be allowed to be on the trademark register actually should be. So that's always quite interesting, and sometimes you go around in circles a little bit thinking about the meaning of words and why things should or shouldn't be a trademark, and what you're trying to get. So then, if we get through all of that, we also have to worry about potential third parties. So we've talked about the fact that we look in these clearance searches to see if anyone else has rights. When you file a trademark application, once you get through and you've persuaded the examiner that there are no absolute grounds to object on, so it can function as a trademark, you then have what's called an opposition period for other people to say, wait a second, I own some earlier rights. So we often have that. Now, usually if we've done the first stage properly, we will have said to people, these are the people with the closest earlier rights, and the client will say, go ahead, file the application. Then these other people will pop up and say, wait a second, we've got the earlier rights. So then at that point, we get into the opposition fight with these people. And again, that will take different forms. Sometimes it's fought through, sometimes it's there and the parties enter into some sort of coexistence or settlement arrangement where they're both quite happy that in practice they do different things, even though on paper they overlap a little bit on the register. On the design side of things, like I said, getting the protection is quick and easy. There's no opposition procedure, there's no substantive examination. It's quick and easy. That does mean that there are a lot of design registrations out there that have never really been tested, which can get interesting. So then once we've got the rights in place for a client, then we need to use them, or we need to make sure that they're being, they're there for a reason. And one of the biggest issues we have with a lot of clients is the fact that they think so a lot of them think that they have to have a registration to be able to use a brand name or a trademark, and they don't. The point of registering a trademark is so that you can stop other people using it and stop other people registering it. So if you've gone through this process to get yourself a registration, then you need to actually be policing the registers and be policing the marketplace. Firstly, because why did you bother if you're not going to do that? But secondly, if you don't do that, you actually have issues where your own rights could become vulnerable and you could end up losing them by something becoming generic or otherwise sort of being eroded a little bit. So that's the typical Hoover example. There are lots of examples of things that are now generic terms that, if the registers and the marketplace had been policed a bit differently, could potentially have actually been brands, but aren't. So that's the other big thing that we do. So we look at registers, so we can put in place trademark watching for clients. So they will then we will get an email every day with, okay, here are all the details of other people who have applied for similar things. Now, obviously, there's a lot of computer algorithms go on behind the scenes with that. It's getting more and more sophisticated, but you still get a lot of things that maybe aren't quite close. So one of our jobs is to sort of sift through that with a human mind and think about whether these things actually are similar. And then equally, it's looking at what's actually happening on the marketplace, which again is a big thing that a lot of people don't really think about. A lot of companies just rely on their own consumers to let them know if something is similar to theirs, or their own friends and families. In this day and age, the biggest problem for most people is the internet and online marketplaces. But again, the technology is getting more and more sophisticated for people to be able to monitor activities of others. Lots of the online marketplaces do have takedown procedures. So you can go to the likes of eBay or Facebook or lots of other online platforms and say to them, here's my trademark registration. Someone else is doing something that is using this in a way they shouldn't. And most of them have fairly straightforward procedures where if you have got the rights and you can show a certificate, then they will take the things down. Now, there are ways for people to contest that and it become a bigger thing, but more often than not, these parties will then just go away and find someone else's brand to rip off, to be honest. So that's the other big thing that we deal with. So before I get on to Brexit and all of that side of things, has anyone got any questions on the first section?
How long does it take to train as a trademark attorney?
So that is a good question. The current process is effectively 2 years of courses. So you have to have 2 years of training on the job. So you have to have a minimum of 2 years practical experience. So you usually do the courses. So the shortest amount of time you can do it within is 2 years, but it depends a little bit on firms and times of year. So whilst most law firms run the solicitor qualifications in set timetables, the attorney side of things tends not to be quite so rigid. So sometimes people will start halfway through a year, so it's too late for them to join the university course for that year, so it might take them a little bit longer. The system was a bit different when I trained, so I think it was about 4 years from me starting to being fully qualified. So it's roughly somewhere between 2 and 4 usually. So Brexit. So just brief overview on this. The reason Brexit is especially interesting to people like me who spend their life looking at trademarks and designs is because you can have EU-wide unitary trademarks and design rights. You can't have that on patents, but you can have it on trademarks and designs. So it's interesting because you will actually see in some of the mainstream discussion about Brexit, these issues do actually come up. So I'll give you a quick overview of the current systems, what's likely to happen to these existing rights when Brexit happens, and then the likely effect, as we think it might be, on people like me who actually work in this area. So at the minute, if you want to get registered trademark protection in the UK, you can go to the UK Intellectual Property Office and get a trademark registration. That covers you in the UK. You've got rights in the UK. You can stop other people using and registering in the UK, but it doesn't really help you anywhere else. Now, Normally, you have to go to all the different countries to get your protection, and pre-EU TMs existing, you had to do that in the EU. So if you wanted rights in France, you had to go to the French registry. If you wanted rights in Germany, you had to go to the German registry. Obviously, that all adds up when you've got lots and lots of countries. So an EU trademark registration was introduced just over 20 years ago. It had a 20-year anniversary a couple of years ago, and that is a unitary right. So you file a single application through the EU Intellectual Property Office, which is a very nice building in Alicante in Spain, and you get your rights. If you get that registered, that gives you rights in all of the EU member states, and it's one single registration covering all of those countries. Now, the positive of that is obviously that is a lot cheaper, quicker, easier than having to go to all of these individual registries and get your rights. And you get one registration covers you to maintain it, so you can renew it every 10 years for as long as you've got the inclination to do so. You do all of that. It's all one single registration. The downside of an EU trademark registration, Brexit aside, is that if anyone has rights in any individual member state, so if someone has some earlier rights that just cover Italy, for example, they can stop you getting the EU-wide protection. So if that happened, you could get national rights. You could go to all the other member states, but not Italy. But then you can't get the EU-wide rights. So again, going back to the clearance search side of things, sometimes we'll end up advising people that actually, if your key markets are only France and Germany, you're probably better getting national rights in those two territories rather than trying to get an EU-wide right, because there are parties in, Italy and Spain that would be able to stop you doing that. So that's the downside of it, but overall, EU trademarks are seen as a very good thing. There are various mechanisms built into the EU trademark system to try and make it an attractive system to people. I've actually written a book about EU trademarks that we were in the process of getting published when the Brexit referendum happened. So I had a fun meeting with the publishers the week after that. But Brexit will obviously have a real impact here. Now, when all the EU trademark legislation was being created, people obviously didn't really think about people leaving the EU. There are provisions for what happens if a country joins the EU and the timings at which the EU-wide rights then cover that country as well, and there are various provisions on that. And just to add some more fun into the mix, the EU trademark regulation was actually changed. There was a big reform of the EU trademark system a couple of years ago, and the reforms have been coming in stages. So the EU trademark system itself, the last bit of the reforms happened back in October this year. There was a new directive which is due to be implemented. The deadline for national implementation is January 2019. Obviously, Brexit is on the cards for March 2019, and the UK Intellectual Property Office, from what I've heard and been told, are still going ahead with everything that they were planning in terms of making sure that the UK system is compliant with this EU directive. But obviously, once we leave, that doesn't have to be the case anymore. So that's interesting. So we'll see what happens there. And then the third thing I've put up here is WIPO registration. So WIPO, for anyone who doesn't know, is the World Intellectual Property Organization. And there is a mechanism to have what's called an international trademark registration, which clients get very excited about and think, oh, that's the worldwide equivalent of an EU trademark registration. It's not. So they think, oh, we just pay one fee and we get the whole world, which isn't the case. What happens with that is you have to start off with a right in your home territory. Once you've got that, you can then go to the World Intellectual Property Organization and say, I want to protect this same mark for this same coverage in all of these other countries. Now, they all have to be members of the Madrid system. So there's a Madrid Protocol and a Madrid Agreement which governs all of this. But effectively, You need to have your home registration sorted first, and there are various rules on what counts as your home, and then you can go to WIPO and get all of this extra. You can do that at the minute. If you're a UK company, you can have your UK registration as your base, or you can have an EU registration as your base because you're within an EU member state. But again, as we'll say, that's going to change. And the big reason that's important for Brexit is because under the WIPO system, if there's any sort of change to your base registration in the first 5 years of the life of the international registration, then the base goes, the international falls over. So you can convert it into national applications in the countries of interest, but effectively you're not in that international system itself anymore. So again, Brexit may have some impact in that. And then I've just put on briefly here about unregistered trademark rights. Now, that's obviously, there are lots of different unregistered rights in different EU member states. For these purposes, I'm talking about passing off rights in the UK, so goodwill, common law rights, which Brexit shouldn't really affect. So that's the good news. The bad news of unregistered trademark rights is that they're kind of difficult and expensive to enforce because it's difficult in the first place to even show that you've got them. So I actually was talking to someone about this morning, a client that's maybe thinking about bringing an action, and I had to explain to them, look, it's an uphill struggle. Yes, we're not saying don't do it, but it's a big thing to get together all this evidence, and you need to have good records, good evidence. The big plus of having a trademark registration is you literally just get your certificate out, or if you've lost your certificate, you go to the online register and it's very clear. There's the mark, there's the registration number, there's the coverage, there's your name. Great. It's very, very easy to show what you own and when the rights date from. So, just touching on designs, the systems are very similar to trademarks in that you can get a UK national design registration. Interestingly, though I think it was entirely coincidental, about 4 months after the referendum result, the official fees for filing UK national design registrations toppled. But I think that was in train anyway. But now, obviously, people are thinking a lot more about UK national systems as a way of getting protection rather than EU systems if the UK is important to them. Now, the other thing you can do is you can do what's called an RCD registration. So that is a registered community design registration, which is the equivalent of an EU trademark, but for a design. That's a single EU-wide right. I'll just briefly say on this, there's going to be a revamp of the community design system in a similar way to what happened with the EU trademark system. So EU trademarks used to be called community trademarks until 2016. As part of the reforms, they've now been called EU trademarks, but we've still got the community reference in the designs. So we get these registered community designs. Again, similar process, you file through the EU Intellectual Property Office and then you get your EU-wide rights, but they're rights that cover the whole EU in a single registration. Now, designs generally are a little bit different to trademarks in the sense that with a lot of these systems, there isn't this substantive examination and you don't have an opposition period, but with a design registration to be valid is supposed to be new and have individual character, and your design is supposed to be novel in the marketplace. Now, you can have someone who says, I've got something that I put on the market in another country before you, that can actually block you from keeping one of these EU-wide registrations. And then the WIPO side of things, again, is a little bit different on designs. So similarly to the trademarks, there is a system where you can do something very, very similar on designs. You do not need to have a home registration to start with, so that's good. But you have to be in a territory that would qualify you. So it's basically, you have to pick a territory the same way you would have to for a trademark. You just don't have to have registered rights in that home territory. At the minute, people can use this international system, which is referred to as the Hague system because it's part of the Hague Convention. You can use that if you're based in the EU because the EU itself is a member. So if you're in the UK, you can use it. Once Brexit happens, people in the UK won't be able to say, oh, I can use this system because I'm in the EU. But the UK is actually in the process of joining that system, and it should be up and running through the UK in April this year. So again, all the timings get interesting on this because a lot of these things have been in train for years and years and years, but now the timing is actually getting quite interesting because of Brexit. And then on the unregistered design side of things, you can get unregistered design rights in both the UK and the EU. So EU, you can get EU-wide unregistered design rights. They last for 3 years. They're actually relied on quite a lot, especially by fashion companies and companies that are churning out a lot of designs very quickly, who realistically don't want to spend money registering every design that they create, and for a lot of them the length of protection will be enough for them. And then similarly you get UK unregistered design rights, and I'll touch a little bit later on the differences. So this is the most exciting slide. There we go. So this is obviously where we are and what is happening as far as we know, though it does keep changing. So what's going to happen after Brexit? As I said, there are lots of question marks from here on in. We don't really know what is going to happen. There is lots and lots and lots of discussion about this. There are lots of papers and bodies that are lobbying other bodies and governments, and there's a lot going on. There's a real concern from business owners that they want certainty. Businesses like certainty. There is also a concern that this is just one thing that's maybe quite far down the list of issues that have to get resolved with Brexit. But as with everything with Brexit, everything is interlinked on this. Now, you may have picked up from my accent, I'm from Northern Ireland. So for me, the whole Brexit thing has a whole other dimension, because I grew up at a time where they were starting to take down the borders. So when I was small, when you moved from Northern Ireland into the Republic of Ireland, you had to go through customs and army checkpoints. That's obviously in my lifetime gone away. There's now the issue that this may come back. But then from a trademark perspective, having spoken to various businesses that are located in Ireland, Ireland is actually one of and people who are in Northern Ireland, a lot of the time will be doing business in Northern Ireland and the Republic of Ireland. How the fees work, it's actually generally, for most people, cheaper to obtain an EU trademark registration than to obtain separate UK and Irish trademark registrations. So a lot of people have gone down this route of, okay, well, let's have EU trademark rights. But now they're thinking, oh, okay, but that means I'll only potentially have protection in the Irish Republic and I won't have it when I go over the border. So that's another interesting side of things. And also from the customs side of things, one of the things that we deal with and one of the reasons that people register these rights is that you can actually go to customs, you can do EU-wide customs recordals where you go to customs and say, look, I've got these registered rights. You give them details of your rights and your product, and then they're on the lookout to see if they can find any counterfeit products. So again, you'll have heard a lot in the news about the customs union and whether we're going to be part of that or not part of that. That actually has a knock-on effect when we're looking at IP protection for people. So this idea of existing rights is one thing, and then there's also what's going to happen with new rights. So existing EU trademarks and registered community designs. There are all these different options. Now, the general view in the UK is, of course, they'll go on to the UK register. That would be crazy if that didn't happen. Surely there will be a mechanism so that people aren't left with nothing. That's not necessarily what is being said by the rest of the EU, and the EU IPO actually released a nice Q&A document a couple of weeks ago that, basically can't say any more than anyone knows. Oh, we don't know, it's all part of the political discussions, it depends on the deal. But the tone of that was a little bit more, well, you might end up with nothing. Who knows? Like we don't really know. So again, businesses liking certainty. There are lots of people who are taking steps now to make sure they're not in that position where suddenly their rights have disappeared. Now, again, everyone does suspect that would never happen, but if it's way down the list and, there are lots of bargaining chips and different things going on with this, so no one quite knows, so people need to be aware of it. But then, assuming that there is some sort of general policy decision that there should be a way of transferring these rights over, there are lots of options that I'll come to look at in a little bit about how that might happen. Is it something that would happen automatically? Is it something that would happen so automatically, so the burden then being on the EU IPO, the UK IPO? No one knows who's going to actually do the work of getting them onto the UK register, who's going to pay for that, because it's going to be a lot of man hours dealing with that. Or should it be up to the holders of existing rights to say, oh yeah, my EU right, I also want that to go on the UK register, and should they have to pay for that, or should it be should there be a free system, or should it be something that happens upon renewal? So trademarks can be renewed every 10 years. So should you say that, okay, well, it's only when you get to renewing it that you have to make that decision, just EU, or also get it onto the UK register? And then the other issue that's an issue for trademarks but not for designs is whether, when it's going on to the UK register, should it just go on as a registered right? So should it be, it was on the UK register, it was on the EU register, now it's on the UK register, it's on as a registered right, or should it have to go through an examination process? Now again, because we have harmonised law, it should be the case that if you file a trademark application in the UK and the EU, that you get the same outcome. But that is subject to the fact that in the EU, when they're examining it, they're looking at all the EU languages. So the average consumer in the EU maybe has different understanding of certain languages to the average consumer in the UK. So that generally means that it might be more difficult to get an EU registration than a UK. So you might be able to get a UK registration for something that UK consumers wouldn't know what the term meant, but actually Croatian consumers might perceive it differently, so that would block you getting the EU-wide right. That said, sometimes it can be easier to get something through under the EU system than the UK system. So there are some things that are on the EU register that probably wouldn't have gotten onto the UK register. So then there's a policy consideration with that as to whether we want those things that got made their way onto the UK, onto the EU register, to now be able to go onto the UK register. So there's lots to think about. Other things, once you have a trademark registration, you have a period of 5 years to start using that. Once you get to this 5-year point, people can then attack it and say that you've not been using. Now, the rules for the EU are that you need to be using in the EU. You have to have, some sort of market share in the EU. Now, there's lots of case law and discussion about whether it has to be used in one country or different countries. The general thrust of it is that they're trying to see the EU as a single market, so all of these territorial divisions are kind of irrelevant. Yes, in theory, use in one country is enough if that use is a big enough part of the EU-wide market in those particular goods or services. So that's the general thrust of it. But again, practically speaking, people worry about territorial divisions. So one of the issues on this is if EU rights get transposed onto the UK register, firstly, what will the dates be? So if it got registered in the EU in 2012, does it have a deemed registration date of 2012 in the UK, meaning that it's already open to attack by the time it gets on the UK register? Or does it have a deemed registration date of 2019, in which case you've now got another 5 years before someone can attack you in the UK? So that's a whole issue. And then there are real issues for a lot of companies who use maybe only in the UK, but when the UK is part of the EU, that UK use is enough to maintain an EU registration. When the UK is not in the EU, that'll be fine to maintain a UK registration, but what do they want to do with what remains of their EU registration? Similarly, you get lots of people who will only be using outside the UK, but they're UK companies, or we've got the Irish example where people have bits in different jurisdictions. So there's basically, I could go on for about 3 hours on all the issues on this. There's a lot of potential issues, and chances are, with all of this, given the speed this is likely to happen with, we're not going to get a very refined answer on all of these points, and there will be lots of things coming out of the woodwork over the coming years. And then looking at the design side of things, it's a little bit different. So we don't have this same non-use attack. So registered designs in the UK and the EU, you can get a design registration that lasts for up to 25 years, and that's in 5-year chunks. So you have to renew every 5 years. And then when you get to 25 years, that's it. But one of the biggest differences between the UK and the EU system is that in the EU system, if you put a description in with your application, that doesn't affect your scope of protection. So EU designs are basically all about the pictures. So everything is to do with what you can see on the register. So it's all about the images that you can see and what's shown in those images. And there was a whole issue around that with the Trunky case a couple of years ago that went to the Supreme Court here. And since then, in particular, people have been very, very keen to make sure that the pictures show the right thing and nothing more and nothing less. But you can put in this description. There's a space in the online form where you can put that in. But generally, it's a bit of extra information. It doesn't really have any legal effect. In the UK, having a description does have a legal effect, and it does affect the protection that you get. So what's going to happen if you've got all these EU registrations that have descriptions that have no legal value and no legal meaning when they're on the EU register? You then put it onto the UK register. Are you narrowing down the scope of protection that people get? Maybe, possibly, but by the same token, if you don't let them transfer them over, then they have nothing in the UK, so what's the harm? The other issue on designs that makes it a little bit more different, bit more tricky than trademarks is that with a trademark, realistically, and some people do this, if you're a bit concerned at the minute, you can go and just say, look, it's going to take too long for all these decisions to be made. I'm just going to go and file my own UK application. I'll have a period where I'm protected in the UK and the EU, and then if the EU says, nah, you just lose the bit of the UK that's in the EU registration, I'm fine. I've already got my UK registration in there. I've stopped anyone else trying to sneak in to get my UK registration. I'm fine. I maybe have, double protection for a bit, but that's fine. When you get to designs, you can't technically do the same thing because a design has to be novel. Now, if you're looking to register a design in both the UK and the EU, you do get 12 months from your own first disclosure of that design to be able to get a registration and not destroy your own novelty by your own disclosure. So that's great, but there's lots of registrations on the EU register that are way more than 12 months old. So what's the point in putting them onto the UK register, well, people then have the rights. If you don't put them onto the UK register, people can't go and refile for that same thing because it's not new. And the way you can show that is by saying, here's an EU registration. It's very clear. It's not like someone has to say, oh, I find a really obscure article somewhere that disclosed this. It's very clear there is an EU registration. So there's a more difficult policy issue around that. And I've actually been helping advise the Chartered Institute of Trademark Attorneys on their position paper to be going to the government on the design side of things, and there's all sorts of colour-coded charts, and it's all a little bit fiddly and complicated. But again, that's probably even further down the list than trademarks, because the registered design system is nowhere near as big, and the register is nowhere near as big as it is for trademarks. The other related issue on this is that under both the UK and the EU system, when you file for a design registration, you can do a thing called deferred publication, which is where you file your application to get it in there, but you keep it hidden because you want to think about protecting it elsewhere, or you want to keep it hidden until you're ready to make some sort of public launch. Now, there are differences in the time periods that you can do that for under the UK and the EU system. So again, it's not quite clear what would happen. So in the EU system, once you file, you can keep it hidden for up to 30 months. Under the UK system, you can only keep it hidden for 12 months. So lots of companies file these things and keep them hidden. So Dyson, for example, does that quite a lot. And you can see that they filed something, but you don't know what it is. The design hasn't been disclosed. So then you potentially will have a time period where people have filed intending to make use of a 30-month period because of how their internal, timelines work. But then if those rights go onto the UK register, there's only a 12-month period. So again, things are changing. So, let's see how we're doing on time. I'm going to just very quickly go through this. These are the different options on what might happen. These are the different models that are being bandied around about what might happen with registered rights. Now, you'll see a lot of these are named after countries. That's to do with things that have happened in the past involving some of these countries. Now, all of these, and whether any of these actually happen, it's all a political discussion. So EU Plus, as people are calling it, that is, and this is what everyone would really like and is probably not going to happen. Instead of having EU systems, we have European systems. So it's a unitary right that covers all of Europe. Now, by that people mean the EU plus the UK, but then you get issues with the other European countries that aren't part of the EU, and that's a bigger discussion. There's what's called the Jersey model, where the UK just says, we're just going to treat anything that's on the EU register as being protected in the UK. So it's a unilateral decision by the UK to do that. Maybe that would happen. Then we've got these other options where you have duplication of the EU stuff onto the UK register. But again, it's whether it's going to be automatic or upon request. And then the veto option is where the UK IPO can raise an objection and say, no, we don't want that to go on the register for whatever reasons they may have. Then we've got the Irish option, which is the EU-wide rights are deemed to give you protection in the UK until the point that they're due for renewal. And then at that point, you can opt to have them duplicated onto the UK register. That option, many people think, is a good option, but the difficulty with that is that it prolongs things for quite a long time because, people could be filing right up until just before Brexit. So we're looking at 10 plus years because it can take years for a trademark to actually get registered. So that's potentially prolonging things. And then we've got this conversion option where we have these EU rights going on to the UK register, but as if they were new applications, which then affects these non-use dates later. But it does mean that even though you had a EU registration, you may not get a registration in the UK. You might have a problem along the way. So unregistered rights, no change for trademarks, goodwill passing off, all of that's going to stay the same, hopefully. And that's fine. On designs, the UK unregistered design right only protects 3D designs, or as I mentioned before, the EU one protects 2D and 3D designs. Now, that is meaning there is a potential gap for people who rely on the EU unregistered rights who have two-dimensional design. So again, a lot of this is important in the world of fashion, where people who are relying on these designs may not have protection. The other reason it's interesting is because you need disclosure in the EU to trigger these EU unregistered rights coming into existence. There is a concern that this is going to have an impact on things like London Fashion Week, because if you're no longer in the EU, then you're not going to get the EU unregistered design rights with your disclosure at London Fashion Week. So people are talking about all different options around that. And yeah, we've already talked about the grace period. So, things for brand owners to think about is basically comes down to, do they wait for decisions to be taken on all of this, or do they refile now, have double protection, maybe have spent money that they didn't need to, who knows. Then, should people be thinking about filing for registered design protection for 2D designs to prevent future gaps? Probably. Now, there are some pushes to try and get all of the design law, so UK and EU, sort of reformed a little bit, and in particular the UK, and people see this as an option to improve the UK unregistered designs system and actually broaden it out so it's more similar to the EU one. But again, I'm not sure who's going to have time to be dealing with that when there are the other Brexit issues to deal with. And then, yeah, do we need to be filing for fresh protection where we might have non-use issues because of where in the EU we've been using? The other thing that I'll just mention very briefly is agreements. So I did say before, a lot of the time we deal with things where we then have coexistence agreements, etc. A lot of the time the territory of an agreement is defined as the EU. So lots of people are changing their drafting on that side of things. But actually there's a lot of companies now going through and looking at all their existing rights. You'll be aware of various disputes that have gone on in the past relating to very, very old coexistence agreements. So the Apple one is a big one with the recording company and the computer giant. They had a coexistence agreement relating to music at a time where, music on computers and streaming of music and MP3s was, not even thought about by anyone. So there are lots of potential issues sitting in drawers all over the place. So people are now starting to look at these things. And very, very quickly, lawyers are a little bit concerned. I personally now spend a lot of my time talking to people about Brexit and what impact it might have, and trying to keep people calm when we don't really know what's going on. In terms of that side of things, there is a lot, and lawyers are quite busy advising on Brexit and talking about that. But in terms of just the bread and butter day-to-day work that we do, there are potential issues there. So a lot of the work I do is in front of the EU Intellectual Property Office. People, again, are lobbying to make sure that people who are qualified in the UK will still be able to have the ability to do work before that institution. But again, we don't quite know what's going to happen. Lots of people are taking steps to qualify in other EU member states, and I personally have qualified in Ireland. The benefit of being born in Northern Ireland is that I can have Irish citizenship and British citizenship, so I'm still an EU national even after Brexit, but also a UK national, and I've been able to qualify in Ireland, an EU member state. And actually, for solicitors, that's a lot easier. So as a trademark attorney, I had to go over, do an exam, learn about Irish trademark law, do an exam on that. It's basically the same as the UK, so it wasn't too bad, but solicitors just have to fill in a form and pay a fee. So a lot of them are like, oh, I'll just do that. But barristers also have to go over and do an exam. So there's another thing to think about. And again, just last couple of points on here. Whatever happens, however this pans out, UK companies will still need protection in the EU. The UK isn't going to suddenly completely stop, and UK companies aren't going to suddenly completely stop ever trading in the EU. And equally, the UK is still going to be an important market for people in the EU and elsewhere in the world. So there will still be a lot for all the lawyers to do. And there we go.
Thank you very much.